Hello, my name's David Winch. I'm a chartered accountant with Bartfield's Forensic Accountants. And in this 30-minute webinar today, we're going to do part four, the final part of our sessions on confiscation questions for the court to answer when it is making a confiscation order. So we'll start, I'll briefly run through the 8 key questions which we've seen before, and then we'll come on to the final 2 questions which we are addressing today. How much time should the defendant be allowed to make payment? And how long should the default sentence be? Now, these are a couple of questions that sometimes are kind of neglected at the end of confiscation proceedings. They're a bit of a fag end that nobody bothers too much about them. But there are 1 or 2 quirky little things that it's as well to be aware of. And then when we've dealt with those 2 questions, I will briefly round up and talk about what we will be doing in a fortnight's time. And finally, I'll talk about how Bartfield's Forensic Accountants can help you. Okay, let's kick off. The 8 key questions that we've seen before. Question 1, does the court have power to make a confiscation order? Does the defendant have a criminal lifestyle? What is the defendant's benefit? And of course, that particular question is really often the most difficult and complex of all 8 questions. How much of the defendant's benefit was obtained jointly? What is the defendant's available amount? And that sometimes is the most important question, because the amount that the defendant is ordered to pay is quite often based on his available amount. What should the defendant be required to pay? And that brings in questions of proportionality that we dealt with a fortnight ago in part 3. And then today's topics: how much time should the defendant be allowed to make payment? And how long should the default sentence be? So let's go with question 7. How much time should the defendant be allowed to make payment of the amount that he's required to pay under the confiscation order? Well, the statutory provisions are in section 11, and section 11 was amended, in fact, wholly replaced in 2015. And the reasoning was there to make it a bit tougher. So the first position, step 1, if you like, is that the defendant should be required to make payment in full immediately on the day the confiscation order is made of the entire amount. In practice, that's very often not feasible. So step 2 is that all or part of the amount required to be paid may be deferred to a date or dates no more than 3 months after the date on which the confiscation order is made. So you can see that different dates can be specified for different parts of the total amount required to be paid, and we'll say a little bit more about that in a minute. And then step 3 is that on application by the defendant, all or part may be further deferred to a date or dates not more than 6 months after the date of the confiscation order. So an additional 3-month period. And that, as far as section 11, is as far as you can go. So the maximum under section 11, that period of deferral you can obtain, is 6 months from the date of the confiscation order. And as practitioners will know only too well, it's quite often difficult or even impossible for the defendant, with the best will in the world, to realize all his assets and pay over the available amount even within 6 months of the date of the confiscation order. And whilst you might say, well, defendants could start putting their house up for sale or something before the confiscation order is made, in practice, I've never seen a defendant who's willing to put his house on the market and say, I know I'm going to have a confiscation order. I know it's going to be based on my available amount. I have equity in the house in which I live with my family. So we're all going to be on the street, and I'm going to put the house up for sale and do that before there's a confiscation order in place. It's just very, very difficult, isn't it, to imagine a defendant doing that. So let's talk about those deferrals. The statute provides that if the court making the confiscation order, and this is the statutory wording in section 11, if the court making the confiscation order is satisfied that the defendant is unable to pay the full amount on that day, that's the full amount on the day the confiscation order is made, it may make an order requiring whatever cannot be paid on that day to be paid in a specified period or in specified periods, each of which relates to a specified amount. So the steer, if you like to call it that, the statutory steer is very much get it paid now. And the court is enjoined, if you like, to be very firm about this, to say, right, only the amounts that cannot be paid today can be deferred, and they've got to be deferred to a fixed date or dates. So why might there be deferral? Well, there might be a short deferral to allow monies to be transferred from an account or released from a restrained account. Sometimes you have, there might even be money in an account controlled by the police, which is the defendant's money, and is going to be used in part to satisfy the confiscation order, but it's going to take a couple of weeks to sort that out, to make that transfer. And so there might be a delay of 2 weeks or 4 weeks or something like that to allow the mechanics of the transfers to go ahead. And particularly if the defendant has money in a bank account that's subject to a restraint order, then the bank who've been served with the restraint order aren't going to transfer that money straight away based on a phone call. They're going to want to see that the restraint order has been lifted or varied to allow them to make that payment. So there's steps that need to be taken, and that's going to take perhaps a week or two, perhaps a little bit longer to sort out, even where there is, if you like, cash in the bank that one would think is immediately available. But there could be a longer deferral to allow a property or a vehicle or some other asset to be sold and the proceeds collected and paid over. And of course, there may be particular delays where an asset is overseas. The statute requires this separate application for step 3. And typically, that will be made towards the end of the first period of deferral. So we've got a situation where the confiscation order is made today, that's the 24th of February. The money is due to be paid by the 24th of May, let's say. As we get towards 24th of May, it becomes clear that the house hasn't yet been sold, the money isn't going to be available in time. The defendant needs more time to pay. And then he needs to make an application to the court for a further 3-month delay. Now, that application must be submitted. It doesn't have to be heard by the court, but it must be submitted to the court before step 2 deferral period has ended. So if the confiscation order is made today, 24th of February, then we need to get that application into court before 24th of May. And interestingly, there's actually nothing to prevent that application being made and heard on the same day that the confiscation order is made. You don't, as a matter of statute, have to wait 2 or 3 months to make that application. You can make it on the day the confiscation order is made if it's obvious that there's going to be a need for 6 months. But what does have to happen is that the step 2 deferral has to be granted first, and then the step 3 deferral. So I've seen, for example, a case in which a confiscation order was made at 11 o'clock in the morning, and it was agreed that the defendant have 3 months to pay. 2 o'clock the same day, the parties come back in before the judge and say, can we have a further 3 months? And the judge says yes, because it's obvious that it's going to take 6 months. But that probably wasn't the intention of the legislators when they made the Section 11, but that there's nothing in law to stop it. Okay, so that's the Section 11 with regard to deferrals. Why does it matter? Because let's face it, if there's going to be enforcement for non-payment, even if all of the payment is due today on the day that the confiscation order is made, by the time we get to an enforcement process, weeks and months will have passed. So as a matter of practicality, that deferral will have occurred because the thing hasn't been paid. So what's the purpose of all this deferral? Well, one of the key purposes is to do with interest, because interest must be charged on any amounts paid late, and that's in Section 12. So a deferral has the effect of delaying the due date, which delays the date from which interest starts to run. So even where we know before we start that the defendant is saying, I've no money, there's just no way I can pay this amount that I'm required to pay. You can give me until the end of time. I won't be able to pay it. Even in those circumstances, it makes a lot of sense for the defense to get a deferral, and then if they can get a further deferral for the maximum of 6 months to delay the date at which interest starts to accrue on the amount required to be paid. The interest is simple interest, not compound interest. So there's no interest on the interest. There's only interest calculated on the principal, but it's calculated day by day, and it's based on a rate of 8% per annum. Now that 8% rate is the rate that applies to civil judgments in the civil courts. It doesn't vary very frequently. I don't think it's been changed for decades. At one time, it was quite a comparatively generous and low rate of interest compared with borrowing from the bank. Of course, these days, bank interest rates are much, much less than they once were, and 8% seems like a punitive rate. But it's still 8%. So 8% interest is going to start running on the amounts that have not been paid from the due date. So if you get, say, a 6-month deferral, you're effectively saving 4% of that principal amount for the defendant. That is 6 months at 8%. The interest is added to the amount required to be paid under the order. But curiously, you might think, if we are facing a default sentence, and as we'll come on to in a minute, a calculation is done of how much of the default sentence the defendant has to pay, which is based on how much of the amount ordered to be paid has not been paid, then the interest which has been added on is ignored in that computation. So that's what this means. It's ignored in any pro rata calculation of the default sentence on part payment. So there we are. We're stuck with all that, aren't we? Or are we? Is there a get out? Is there a way around some of these problems created by Section 11 and Section 12 for the defendant? Well, perhaps there is. The statute does not specify what should happen regarding the due date and interest when a confiscation order is varied rather than made. Now, you might say, well, if you're varying a confiscation order, you're making a confiscation order. I would say, well, no, you're not. There are different provisions within POCA dealing with making a confiscation order and varying a confiscation order. There are different provisions in the Criminal Appeal Act to do with making a confiscation order and varying a confiscation order. So I would say that when you vary a confiscation order, you are not making one, you are varying one. So what does section 11 and section 12 say about when a confiscation order is varied? Well, they don't say anything about it. They don't mention at all what should happen to the due date and the interest and so on when a confiscation order is varied. But in practice, where a confiscation order is varied under section 23, courts behave as if the due date under section 11 provisions applied to the date on which the confiscation order was varied and not the date on which it was made. And interest which is accrued up to the date of variation just evaporates. It just goes away. There can therefore be significant advantages for a defendant if the court varies an order under section 23, because all that accrued interest just disappears, and he may get even a further 3 months or whatever to pay after the date of variation. One's tempted to think, well, is it worth making a section 23 application just for a few pounds of shortfall in order to have the interest evaporate and in order to get a new due date which is later than the due date based on the confiscation order? Well, that's a possibility that lawyers for defendants might want to think about. Okay, so that's covered question 7. What about question 8? How long should the default sentence be? Now, again, this is something that doesn't receive a lot of attention always. I have known cases where the judge will finish up by making the order and saying, right, defendant to pay £400,000 and the default sentence is 5 years. Okay? And everybody says, yeah, fine, done. And there's no thought being given to it at all. And indeed, I've known cases that have finished up in the Court of Appeal because exactly that has happened, that a default sentence might have been set, which is inappropriate, too high, and the defendant has appealed against the default sentence and had it reduced in the Court of Appeal. Incidentally, again, another little quirk, if the default sentence is set too low, and the prosecution feels that the default sentence needs to be increased, but the amount ordered to be paid is okay, the prosecution cannot appeal purely the default sentence. Where a confiscation order is made and the amount ordered to be paid is wrong, the prosecution can appeal. Where the court decides not to make a confiscation order at all and the prosecution feels a confiscation order should have been made, the prosecution can appeal. Where the situation is that the benefit figure is okay and the amount ordered to be paid is okay, but the default sentence the prosecution feel is too low, they cannot appeal solely that item. But the defense can. The defense can because it's a sentence. So, how long should the default sentence be? Well, the statutory provisions for when an order is made, and not for when an order is varied, when an order is made are found in section 35 of POCA. Again, that's been subject to amendment over the years as governments have tried to toughen things up. So there is a table of maximum sentences in what is now subsection 2A of section 35. And this table relates to the amount required to be paid. But, and this is important, but the court has a discretion to fix any default sentence which does not exceed the maximum shown in the table. There is no minimum. So recently I had a case where the amount ordered to be paid was sorted, according to the table, the maximum default sentence which could be set for that amount was 5 years, and the judge was persuaded to set a default sentence of just 7 days. That was unusual circumstances, but it's perfectly proper for the judge to do that. And one does wonder whether having such a short default sentence might have helped the defendant, who was then a serving prisoner, might have helped him in getting into a Cat D situation, and so on and so on. So that there is relevance to all of this in terms of the welfare of the defendant. The bans in the table in this subsection 2A are broad and they are non-linear. So what I'm saying here is that doubling the amount ordered to be paid doesn't necessarily double the length of the default sentence. And default sentences, let's not forget, default sentences where they have to be served are always consecutive to the sentence for the actual offence. So let's look at the table of maximum default sentences. Here it is. If the amount's £10,000 or less, the amount ordered to be paid is £10,000 or less, the maximum term is 6 months. If it's more than £10,000, but not more than £500,000, so that's a very, very broad band, it's 5 years. And if it's more than £500,000, but not more than £1 million, it's 7 years. If it's more than £1 million, it's 14 years. So as you can see, when I was talking about it being non-linear, if the amount of the ordered to be paid is £500,000, maximum is 5 years. If that doubles so that the amount ordered to be paid is £1 million, the default sentence doesn't double to 10 years, it becomes 7 years. So what's the purpose of the default sentence? Well, the purpose of the default sentence is to secure payment of the confiscation order. It's to encourage the defendant to pay up. One should remember that if the defendant is required to serve the default sentence, that's not in place of, instead of paying the confiscation order. It is, if you like, a sentence for failing to pay on time. If the default sentence is served and the amount still hasn't been paid, then the courts can still enforce payment by getting an enforcement receiver appointed, taking over the defendant's assets and selling them, and so on and so on and so on. So the debt is still there, even if the default sentence is served. But the purpose of the default sentence is basically, it's a threat. Pay up or you'll serve extra time. Now, the default sentence isn't about punishment for the offence. And when default sentences are set, the totality perspective, which applies to sentencing for offences, does not apply to default sentences. They're just regarded as separate. So the judge is not going to say, right, you've got 5 years for the offence, and I would have given you 7 years for the default on top, but 12 years is just going too far, so I'm not going to do that. No, that doesn't happen. That totality argument just doesn't happen with default sentences. All the circumstances have to be considered when the default sentence is set. It's not purely an arithmetical exercise. It's not a case of saying, because the default amount is £300,000, then we can whip out a calculator and work out what the default sentence has to be. There is a leading case back from 2011, Castillo case. Paragraph 12 of that will show you some of the things which the court was taking into account in that case. But there is, of course, a rule of thumb, and in general, the court will set a default sentence which is not less than the maximum for the band below. So if, for example, we've got an amount of £11,000 required to be paid. If we look at our table, the maximum for amounts up to £10,000 was 6 months. So we're above that band. We're into the next band where the maximum is 5 years. The court is not going to set a default sentence for £11,000 normally, which is any less than the 6 months sentence that would be the maximum if the amount was £10,000, the maximum of the band below. And other things being equal, the larger the amount that's required to be paid, the longer is going to be the default sentence. As I say, other things being equal. What about very large amounts? What about when we get beyond 1 million? Well, in practice, a confiscation order, say, of £2 or £3 million is likely to attract a default sentence of between 7 and 10 years. And default terms in excess of 10 years are likely to be reserved for those very rare cases where extremely large amounts are required to be paid. And remember, it is about the amount required to be paid. It's not about the benefit figure. One other little quirk, tainted gifts. A tainted gift, as we know, is included within the calculation of the defendant's available amount. So the defendant may have given something away, perhaps years ago, which is caught by the tainted gift provisions, either because the gift was after the first period of his offending, or the gift was after the relevant day in a criminal lifestyle case. The money's gone, and it may actually be totally irrecoverable for the defendant. With the best will in the world, that he's given it away, he can't get it back. A genuine gift. And the court might be absolutely satisfied that this is a gift which cannot be recovered, either by the defendant or by the operation of law applied to the recipient. Nevertheless, it falls within his available amount, and therefore it may fall within the amount that he is ordered to pay. So he's going to finish up serving a default sentence because he's not going to pay it. He's never going to pay it. He can't do it. So he's going to finish up serving the default sentence. So the defendant may find himself facing an available amount, including a tainted gift, which is, for all practical purposes, irrecoverable. What do we say about the default sentence? Well, in this situation, the court may set a default sentence which is shorter than would otherwise be appropriate. And there's some case law on that, the case of Johnson. It's worth looking at if your client is in that situation. I must say, I'm not a big fan of it myself, because it seems to me that it kind of cuts across what default sentences are for. But nevertheless, that's the law, that's the case law, and you can use it. Now, I did mention pro rata release, and with one exception, which we'll come to in a moment, default sentences, like other sentences, the defendant is released unconditionally at the halfway stage of the sentence. So that operates in exactly the same way, with this one exception, as it does for other sentences, unconditional release at half time. The exception is where the amount required to be paid exceeds £10 million. And of course, that doesn't happen every day of the week. The sentence to be served is also automatically reduced pro rata in proportion to the amount which has been paid of the amount required to be paid. And as I say, in this computation, we ignore the interest altogether. So let's have an example, because I love figures, I'm an accountant. If the amount required to be paid is £400,000, and let's say the court has set a default sentence, as we know the maximum band we're in, the maximum is 5 years, but say the court sets a default sentence of 4 years for this defendant who has to pay £400,000. And let's say the defendant actually pays £100,000 of that. So he's paid 1/4 of the amount. So the sentence has to be reduced by 1/4. It was 4 years. He's going to be instead having a default sentence effectively of 3 years because of that part payment. And as I've said, it's mandatory that he gets released at the halfway stage. So he's going to actually expect to serve half of that 3 years, 1.5 years. That's how that works. In practice, it's calculated to the day and so on. And obviously, I've made just a rough approximation here for this purpose. So you get the gist of how it works. Okay, so that's us done. We've done the 8 questions that the court has to address when it is making a confiscation order. I hope you have found that useful. I know 1 or 2 people actually watch the recordings and stick me on pause and playback so that they can take notes or listen again to particular points. I hope that's not too awful to contemplate. Good luck with that. But in a fortnight's time, we're going to be on a new topic. We're going to be looking at the interrelationship, or sometimes lack of interrelationship, between a defendant's benefit and his available amount. And we're going to look at cases like Bowick and Telly and Macintosh and things like that. So that will be in a fortnight's time. In the meantime, of course, Bartfield's forensic accountants remain fully staffed. We undertake legal aid work, we undertake privately funded work, criminal work, civil work. Fortunately for us, we are very much online and able to work through the pandemic. And we are readily contactable by phone and email and online. And of course, the updates on the website can keep you up to date, and you are able to access them 24/7. You can see more on this topic and others on the news section of our website, and this and the previous webinars can be found on the seminars section of the website, where you can access the recordings. In any event, we will send you a free copy of the recording of this webinar. We'll email that to you. If you need to get in touch with me or want to get in touch with me, then please do email me, and my email address is there on the screen, or you can phone the office, although I have to say I'm not spending a lot of time in the office at the moment. But best way probably is to email me, and I will certainly get straight back to you. Thank you very much again for your time, and I look forward to seeing you in a fortnight. Thank you, and bye for now.